Okay, so welcome to the estate planning training. I'm Vijaya Singh. I'm one of the staff attorneys here at VIP, and this is
Hi, Kelly Gastley, the managing attorney at VIP. Consider me Vijaya's sidekick for this training, because Vijaya is really the one with a lot more of the, I try not to say expertise, because in the legal world, I get in trouble saying an expert, you have to be actually certified to be an expert, but Vijaya has a lot of the knowledge in this area, but I'm tagging in and helping a little bit, especially with the wills section we'll discuss toward the end.
Is anyone virtually having trouble hearing us or anything? Will you please shoot a message? Everything's good?
Yep, nothing so far, so.
Perfect. Alrighty, so just a brief agenda. We done. Let's get that. This is the two of us. So I know some of you are new to Philadelphia VIP, so I wanted to go through give you a little bit general information about what we do. We leverage powerful resources of the community, our volunteers, to provide quality volunteer legal services and ensure access to justice for low-income Philadelphians. None of our staff represent our, at least estate planning clients directly. All of the estate planning clients are paired with volunteers who then prepare the documents for them. So Philadelphia is now the second poorest largest city in the US. Sorry, Houston. We have a population of about 1.6 million people, and about 20% of those people live in poverty. Let's see. I mean, that's with anywhere demand for affordable or free legal services are pretty hard to come by. And a normal legal aid where there are attorneys on staff to represent clients, they can only handle so many, right? So VIP tries to fill some of that gap by using the resources of our volunteers to help even more clients who need free services. And even we have to unfortunately turn people away, right? There's only so much we can help. So the more volunteers we have, the more of you who join our trainings and take cases, the more clients we can help. Just a little bit more information. Sorry. The average income for a household of one, especially with our clients, is just under $17,000 a year, which is in today's world not very much at all. When you try to stretch that, if there's just your basic bills and things like that, it's not easy. Okay, so
You want me to take a turn? So that
Sure.
give you a moment, because the guy's gonna cover a lot on powers of attorney right after this, so I thought I'd give her a breather. So we offer a lot of support for our volunteers at VIP, which is really what makes us unique as an organization. A lot of other legal services organizations in Philly do pro bono work as well, and we work really collaboratively with them. But what makes us a little different is that our staff, including myself and Vijaya, are really here just to be focused on you as our volunteers. We do not carry caseloads of our own, with one small exception of our landlord tenant staff attorney, Kate, who does handle a very small number of cases herself for evictions. Otherwise, the rest of us, we're not like running around trying to represent clients directly. We are running around trying to answer your questions, review, in the case of estate planning, review your drafted documents you want us to look at before you have your client sign off on them, whatever it might be. And so that's really how we model ourselves. So we also provide training manuals, template forms. So the powers of attorney and wills that we're going to talk through today, we have template forms that we welcome for you to use. If you have templates you already like to use, that is okay as well. But we don't want you reinventing the wheel. We really want you focusing in this particular work on kind of counseling with your clients and helping them figure out how to best take the wishes they're expressing to you and best reduce those down to paper on these important documents. So we provide you with those templates so that you can really use them as a starting point. And really importantly for this work, we have notaries and office space you can use. So if you need to meet with your client, whether for a first interview or more commonly in these cases, to actually sit down and execute the estate planning documents once they're finalized and you've been working with your client on them, you can come in here to this room. We have another space as well that our volunteer attorneys and clients use to meet with each other. We have 2 notaries on staff. And we also work with other volunteer notaries, as I've spoken with some of you about, who also help, whether it's notarizing documents inside the office or outside the office. So we try to make it easy so that you can kind of focus on just doing the work of representing your clients and not worrying about all those logistical pieces. I'll take this one as well. So, if you take a case with VIP, if you haven't done that before, we will send you a case summary, which is actually what we put up on our website to describe the case we're asking a volunteer attorney to get involved in. And we will send you a short case file for estate planning matters. They are fairly short, because there's not a lot, going on in these cases where you need a mountain of documents and information. But we will put together a case summary that explains what kind of help the client is looking for and where they are starting from with this legal issue. So an example is here that you can see. I won't read it out to you, but kind of describing what the client's looking for and some of the background information on her family situation to understand, okay, this is where she's coming from. She's trying to make sure that her home gets to one child in particular, but also has some other children she wants to make sure are also taken care of generally in her estate plan. You know, how might she do that? We'll talk about some of the ways that can be done. But this just kind of gives you an idea of discreetly what we are asking our volunteers to do. We try to be really intentional with our scope of representation in our case summary so that you know what we're asking you to step in to do. And, you know, if the client needs further legal assistance on some other issue, whether related or not, that's something that we can work with the client back at VIP and potentially find them another volunteer attorney or provide them with another resource for that other issue that may come up. Okay, I'll hand it back to Vijaya.
So, estate planning, of course, is important, even for those with few assets. It helps to avoid intestacy, it avoids having to track down missing heirs, it prevents tangled titles down the line. And it can give guidance for end of life care. It can also preserve intergenerational wealth, assist families in making decisions for their loved ones in tough times. And part of our job is helping the clients have those difficult conversations with their family about what it is that they want in certain situations. For that reason, of course, that's why the counseling piece is so important. You know, they may say, oh, I want my son to be my financial power of attorney, which we'll talk about more in a second. But the son is known for, you know, a gambling problem or something. You know, you don't necessarily want someone taking care of your finances in that situation, right? Or you might want to make it more limited in what they can do. So these are the 4 documents that VIP can help with. We can help with the financial power of attorney, the healthcare power of attorney, and living will. And then, of course, the simple will, which is what happens after you pass. The other 3, the powers of attorney and living will, are only effective while a person is alive. So a lot of people, when you hear estate planning, you think, oh my God, I have to think about when I die. But it's not always just that. It includes other things about, you know, if you can't make your own medical decisions for some reason. And that could be simply because, God forbid, you're in an accident or something and you're unconscious. You're not necessarily dying, but you can't make a decision or give consent to a surgery or other procedures, and someone else has to do it on your behalf. So you're choosing who that person would be. So the powers of attorney, you're choosing, again, someone called your agent to make decisions on your behalf, whether financially or with your medical or healthcare decisions. The healthcare power of attorney and living will, while they are separate documents, they can also be combined since they are somewhat related. And then the umbrella term for that combination of the two is the advanced healthcare directive. Our template has the two combined into one document and it has advanced healthcare directive on it. But we do have clients who occasionally want them separated, or they just want one or the other, and it's very easy to separate them if needed. Agents are fiduciaries to the client. They have to use the best interest of the principal standard. So we'll start with the financial powers of attorney. So again, this is the client or principal is choosing an agent to make financial decisions on their behalf. They can manage their finances just as the principal would. They can access bank accounts. They can buy and sell real property. Anything, they can manage income, pay the bills, anything the principal would be able to do. With the financial powers of attorney, once it's executed and the agent signs their part, it is effective immediately. So there's a potential for both the agent and the principal to be managing those finances at the same time, which is another huge reason why that agent needs to be someone the principal can trust completely. So financial powers of attorney can be general or limited. The general financial power of attorney is broad. It can let them do just about everything I just went over. Or if there's, for some reason, they need it only for a specific reason, they're fine paying their bills, they're fine, managing their property, but they just need someone to access this one bank account for some reason or other. They can set it.
It's Linda giving you a call.
I'm sorry.
Oh, good. How are you?
No, I think someone just says it's unmuted. I'll try to find them. Mute them.
Yes,
It
please.
is, yes.
Muted, please. Sorry about that. Yes, so the financial power of attorney can be drafted to be limited to grant only certain powers to the agent. They can be
rates
durable.
fell really rapidly, and so we would like the water bill.
Hey, Linda Bartosh, I don't think you're muted.
Was putting on a lot of swaps.
We're trying.
Basically hedges. So
I can't, it's not in my list.
and traditionally Morgan Stanley has not been open to hedging.
Why it's not coming up? Oh, okay,
Oh, you got it?
muted now.
Okay.
Okay. Sorry about that, everyone.
What did I do? Okay. There we are. Okay, sorry about that. So the financial powers of attorney can also be durable or springy. Durable just means it takes effect right away. And if something should happen to the principal, whether they lose capacity or become unconscious, for some reason cannot do things on their own, it stays in effect and the agent can continue doing or managing finances. Springing financial powers of attorney, they do exist, but they're not widely recognized anymore. I guess you could say they're phasing out a little bit. It's very difficult to get them to work. So a springing financial power of attorney means it only takes effect when a certain situation happens. Maybe it's by incapacity or something happens to the principal. However, you need a doctor to actually sign off and say, yes, this person is incapacitated. They actually need this agent to take charge, which then triggers the financial power of attorney to have its power. However, a lot of doctors are not willing to do that.
Mhm.
So if there's a time constraint or there's some urgency to the matter, it becomes a big problem, right? So for the most part, all VIP financial powers of attorney will be durable. If a client's asking about springing or anything like that, you're welcome to direct them to us, and we're happy to have that conversation with them.
And you might think that the average person out of the legal world isn't gonna know what a springing power of attorney is, but we're finding that TikTok is educating lots of people these days in good and bad ways.
Yes.
And we're getting a lot of questions. We get a lot of questions about trust, for instance, we didn't used to get. So we never know what's gonna come up next. Don't give TikTok any ideas. But we never know what's gonna come up. So just let us know if that comes up, and we're happy to speak with you or speak directly with your client and make sure that, you know, we explain why that's probably not the best idea for most of us.
As I mentioned earlier, the financial power of attorney takes effect once it's executed by the client and also signed by the agent. So a way to kind of make the durable document springing in a way, the client can actually execute their document and keep it in a safe place, unsigned by the agent, but they have to make sure the agent knows where it is and when they would want them to go sign it. So that if something does happen, the agent knows, okay, I need to go get this document, sign it, and then it has the power I need it to use.
When the agent needs to sign the document, do they need to sign it in front of like two witnesses or anything like that?
The agent does not.
Okay, so they could just like personally.
Correct. Yes.
Can I just ask one question? I went to a seminar or whatever, and the person was trying to explain the difference between a general power of attorney and a durable power of attorney. Is there a difference,
So
or is it just nomenclature?
the question is about a general, is there a difference between a general and a durable power of attorney?
So they're actually slightly separate. So it's more general versus limited, general being broader powers, and then durable versus springing, whereas durable is whether it lasts, how long it lasts, right? So you can have a general durable financial power of attorney. I don't know if that actually answers the question, though. Does that clarify it for you?
Kind of not really, but
Okay,
if you do the power of attorney,
yes.
you go through all the, you know, formalities, then it's automatically durable? Or is there something, if I put general on the top, does it change the meaning of anything in the document?
Just to
No.
repeat, so the question is about like the label that is on the power of attorney. If it says general power of attorney, is that all that's needed to make it general? And I think,
Or durable?
or if it says durable, durable is important to have in the title if it's going to be a durable power of attorney. What's going to make it a general power of attorney is when those powers are enumerated in the document and it is a wide swath of powers, then it's going to be considered general, but there's no other real significance there. And you know, and it can be really, there's a spectrum of general to limited, right? You could choose, a client could choose some of these powers that they want their agent to have and not others. They want them to be able to access, you know, their bank account and pay their bills, but maybe they don't want them involved with transactions related to their home. And they could get very specific. It's not only general or limited, there's a range within that.
Yes.
And can I ask a clarifying question, in terms of the document being effective, it's effective when both parties sign, so not just the principal, right?
So the question
Correct.
is about when is a power of, I just wanna make sure the folks at home are getting it, although you're probably.
So you're pushing forward a little bit here, but.
Great opinion, I'll let you take it then, because we'll bring on to that.
So. Before I just go over this, I just wanna highlight, the financial power of attorney, it's. Created by statute, and it actually, when you look at our template, it enumerates each power that the principal is giving to the agent. So when you're reviewing that with the client, you're gonna go through each power with the client, and they can choose whether or not they want that included in their document. Right? There's one long list, and then there's also this set of what's called hot powers at the end. It's 8 powers, and it gives very broad authority to create trusts, to make gifts on the principal's behalf, to pay money, represent the client in certain things. So those you want to look carefully at with the client, make sure that they're okay with those broad powers given to the agent. So yes, drafting and execution. Again, the client should be picking an agent that they trust completely. While it is absolutely recommended that they pick an alternate, if they don't have an alternate agent that they also trust completely, it's better to just leave them out. And same if the agent they're choosing, if they're talking to you about their agent and it's sounding like this person doesn't really sound like they should be managing your finances, counsel them through it. You know, it might be that they don't do a financial power of attorney at this moment. You know, maybe they want to talk to their family members and kind of figure out maybe there's someone better positioned for this duty, you know? It's ultimately their decision, of course, but you know, make sure they understand what they're signing first, right? So the very first page of the financial power of attorney is a statutory notice that explains to the principal or the client what this document is and what types of powers it includes, right? That statutory notice cannot be altered and it must be signed and dated by the principal. The client or principal has to sign and date in view of 2 witnesses and a notary. That is required by law. Both the notary and the 2 disinterested witnesses, the agents and alternate agents, should not be witnesses, or the notary for that matter. Some clients, they want, well, I want both my kids to be my agent. It's not recommended. Again, if that's what they want, that's what they want, but we don't recommend joint agents because they both need to be in agreement on every decision, every action, and they often have to be in the same place at the same time to make that action or do that thing. So it's much better to have a primary agent and an alternate. Even if the primary agent is living and perfectly fine, but for some reason is unable to do an action, as long as the alternate agent can, you know, provide some kind of proof that says, okay, well, this person is out of the country right now and I need to be able to pay this bill for mom, they should be able to do that. Yes, okay. So for any time a client is going in front of a notary, whether it's for the financial power of attorney, healthcare power of attorney, or the will, they will need unexpired government photo ID to show the notary before the notary can sign off on their signature. You'd be surprised how many clients come in with expired driver's license that just expired two weeks ago or something. It's sometimes you just forget to take a look at that date, you know? So definitely want to remind the client, take a look at it, make sure it's not going to expire soon or it's not already expired, because then they need to go renew it before they can execute their documents, or at least have some alternate form of government issued photo ID. And the financial power of attorney specifically must be executed in front of the notary. This is the only document that by law has to be executed in front of a notary. The other ones it's recommended for, and I'll show you, there's a chart we have at the end that that'll run through all of them. But for the financial power of attorney, you absolutely have to do the notary.
Vijaya, 2 questions in the chat. One, which we talked about a little bit, but does the agent need to sign when the principal signs, or can they wait until later when they actually need to use their power as an agent?
That's a very good question. The agent can sign at any time. And they do not have to sign in front of a notary, in front of 2 witnesses. They just need to sign and date. we recommend that the agent sign in front of the principal or client at the very least, just so the client knows, okay, the right person is signing this, there's no, potential fraud going on here. But that's also why that's an option to create the springing document that some clients occasionally want.
And then the other question is, can you authorize joint agents to act independently? Can you put that in the document? And I don't know that
So you can,
can?
there are ways to do it, but it's very difficult to draft. On the rare instance that happens, we've reached out to our experts to kind of help with the proper language, because it's more of, you have to carve out their independency while also giving them back the power to act. It's a weird little situation, but yes, it is possible. It's just not easy to draft. Just make sure I didn't miss anything. For general knowledge, you can vouch for your client in front of a notary. If you're willing to do that, we would never ask you to do that. And another option is, if the client doesn't have photo ID, if the client knows a notary personally and the notary can, knows this person is who they say they are, the notary can accept their person as their own ID. So, but yeah, if a client is having trouble, just reach out to us. We have a bunch of resources. We can work with them. City IDs are a lot easier to get sometimes than your state IDs and federal IDs.
So we have a lot of experience working with clients who are having ID issues. So we have a lot of tools that we try to use to help clients get over that hurdle. So they have proper ID and also for the immediate purpose of getting the documents notarized.
All right, so moving on to healthcare powers of attorney. So the doctors are legally required to speak with their patient directly, as long as communication is possible. They will only turn to the healthcare power of attorney agent if for some reason communication with the client or patient is not possible. And that could be they're unconscious, they no longer have capacity to understand the medical discussions that they're having with the doctor. And this is separate than if a client walks into their doctor's office and says, I want my sister to also hear what you're telling me. I want her to be part of my care. That's direct communication from the patient, right? So that's separate. But if something were to happen to that client and they didn't have a healthcare power of attorney, the doctor may not be able to talk to that sister anymore without this document in place, if that makes sense. So again, stop doing that. With the healthcare power of attorney, this one is actually automatically springing. It only takes effect, again, if the client cannot communicate directly with the doctor. So again, you want to make sure the client is choosing a trustworthy agent. They should be familiar with the client's preferences, religious beliefs, all that fun stuff. Again, caution them against using joint agents and co-agents. It's the same situation. It can absolutely be done, but we don't recommend it because they need to be in the same place at the same time and on the same page. And if it was tough with money, think of how tough it is with healthcare, right? So that's also a conversation they want to have with their prospective agent, hopefully beforehand as well. The agent should know that they're being chosen as the agent. We have had the occasional person say, no, I'm not willing to do that for you. And the clients come back and said, I need to think of another agent. They didn't want to do it. So you want to be counseling them through these conversations with their family members and prospective agents. And again, this can also be limited or more general. They can limit it to just treatment decisions, but it can also include hiring and firing their current physicians, anything like that. Again, the powers are mostly enumerated within the document. So you'll go through it with the client and strike out what they don't want. You know, there's an other box if there's a specific treatment they don't want or a treatment that they do want, you can write that in and add it in for them. So yes, it can be struck out or deleted, whatever they want, whatever they feel more comfortable with, whatever you feel more comfortable with. So healthcare powers of attorney have to be executed in front of two disinterested witnesses against the agents and should not be witnesses or the notary. It does not require a notary to be powerful. However, it's recommended, it's an extra level of security that says, no, this is what they want, this is what they chose. A notary has actually kind of put their seal of approval on it, I guess you could say. So we will always recommend a notary, and most of our clients will sign in front of the notary as well. And again, the client must have that valid, unexpired photo ID from the government to show the notary.
One thing I want to point out here, I always find it strange that it's permissible to actually physically strike out on the healthcare power of attorney document, because the clients understand they don't want to try to mark up later their will or their financial power of attorney, which is going to cause a lot of issues. And it's something very unique to the healthcare power of attorney that it's permissible to do it that way, to strike out powers they do not want to grant to their healthcare agent. So I just kind of wanted to draw attention and point that out so that you all know, like, yes, it really is permissible. But it really isn't a good, like, you do not, our clients should not be doing that on the other documents. So just kind of keep that in mind, and it might be something that you can kind of explain to the client at the time of execution. Like, while we're doing this now together, as you execute your healthcare power of attorney, you don't want to make other marks on your other documents. A better way to handle that is if you find in the other documents you want to make changes later on, to come back to VIP and we can help them make changes, which we do. We have clients who come
Yes.
back and we'll say something, 2 years later, something changed. Someone named and my will has passed away, whatever it might be, something changed, we'll help them update their documents.
Absolutely. So turning over to the living will. So the living will has a much more specific power. So this is specific to when the client, one, cannot communicate again with the doctor, and two, they have an end stage medical condition. So this means a doctor has said or signed off on saying, this person, regardless of whether I start new treatment, continue current treatment, or just stop treatment altogether, the end result is this patient is still gonna die soon. There's not really any hope left. Right? They're just kind of holding on. We're essentially waiting for them to go, unfortunately. So what would the client want in that situation? So this is where you're saying the client is expressing their wishes as far as, do they want to be on a ventilator at that point? Do they still want CPR? Would they want a feeding tube? These are those fun questions. Do they want organ donation in that situation? And again, this is not car accident. There's hope. They just need surgery or something, right? The doctor's not turning to this if there is any glimmer of hope, according to the doctor. This is not, does not include miracles and things like that, but the doctor has said that, there's not much else we can do here. So it can be a list of, these are the treatments I don't want. Or it can be a simple statement that just says, I don't want any of the treatment, or you know what, give me everything until I'm gone. Depending on what client's wishes are. You could do a checklist or a statement. So this again should be signed and dated in front of 2 disinterested witnesses. You're not naming a person in this part of the document, so it doesn't really matter who's the witnesses at this point. But if it is combined with the healthcare power of attorney, like our template, if you're doing them together, then the agent should not be witnessing. Again, this can be fully executed without the notary, but it's better to have the notary on there. This is where you're talking them through, you need to have these tough decisions with your loved ones about what you want in these circumstances. You don't want to end up in these circumstances and then leave your loved ones kind of trying to figure out what to do, and then you have them wanting different things for you and fighting over it, right? This is kind of a reminder, even to the agent you've already spoken with, it's a reminder to them, because this is going to be a tough situation all around. And even if you've already had that discussion, they're going to be in their own little bubble of, I don't know what to do here, what does mom want? I remember she mentioned this, but would she want it now? Things like that. So it can just give some comfort to the family members. I don't have to make this decision. She already made this decision for herself. Okay, so now I turn it over to Kelly for the wills. Did anyone have any questions quickly before we switch a little bit?
Do you ever have any concerns about the age of the children? Like if the person is older, but they had their children late, so the children are only in their early 20s. At the time you make it, I mean, they could be older, but.
So that's a discussion for the client,
Will
right?
you repeat the question?
Oh, sure. So the question was, are there ever concerns about agents being younger children, like at early 20s or so on, and it's an older client? So yes, it's a discussion with the client about, have you had these conversations with your children? They are on the younger side. Are they comfortable doing these things for you? And a lot of the time they've already been doing all these things for the client, and it's just now you're giving them the official authority to do it. But if it sounds like, this person is running off to college and they're gonna jump countries later, then maybe you talk with the client about, maybe this is not the best agent for you. Let's talk about who's closer to you, who lives near you, who can do these things. Like if there's an emergency, is this child gonna be able to do that?
And sometimes you're asking that question as someone who doesn't know the client's situation is actually going to get them to think about things they may not have been thinking about before, right? Because you don't know their family. You're not saying, well, what about Aunt so-and-so? What about your sister, right? You don't have any emotion wrapped up. So you posing those questions is in a lot of cases going to have the client thinking through these decisions in a way that if their daughter posed that question, they might feel like, oh, well, the daughter's got maybe more emotion wrapped up in it, maybe doesn't have a good relationship with one of the other people being considered, right? But you're really posing it as this more of like yes, you're your client's an attorney, but you're kind of a neutral arbiter in a way of this family. And your job is like, you can ask these prompting questions in a way that's almost very innocent. You have no idea what the answer is going to be, but you're trying to get the client to think through what are all of your options. What are concerns that maybe you haven't expressed to me, but maybe are valid concerns about the people we're talking about or the decisions that you're thinking of, that can really help the client get to what is the best right decision for them and their family. And so that's where, you know, you get to really be that counselor at law. We don't always talk about ourselves as counselors, but this is really a lot about counseling. That's really more of what we ask you all to do. Yes, drafting the documents correctly is important, but we're giving you templates to make that very easy. A lot of it is really about having those conversations and back and forth with the client to make sure that they can reach the right decision.
And we're here to help you with those conversations if you need it. Like, don't hesitate to reach out, you know, I need to discuss this with the client, how do I do that, how do I approach this subject with them? Feel free to reach out to us, we'll guide you through it.
Really good question in the chat. If the agent under healthcare power of attorney does not agree with what's in the living will, what takes precedent?
So the living will itself actually has a section that asks the client to answer that exact question. They can either choose that the living will is the law and it must be followed as instructions, or there's an option that gives the healthcare power of attorney authority to override any of those powers, and with an exception line if the client wants to fill that in. So with every client, it's different, but they are actually making that decision in the document itself to say either that my agent can override this if they want to, or no, they cannot. And the living will is one of those things the doctor's gonna look at it and they're gonna say, okay, well, this thing is law, I don't need to talk to you anymore. Right, this is telling me what I need to do. This is from the client's mouth, so to speak.
And one other question, do agents sign the healthcare power of attorney? Someone just wanted clarification.
They do not. This is the client executes it themselves and provides copies to their healthcare professionals so that they know who to reach out to if they need to reach out. And one thing I did forget to mention before we switch to the wills, the documents I spoke to you about so far, the 3 healthcare power of attorney, financial power of attorney, living will. The second that client or principal passes away, these documents are garbage. They have no power, they do nothing. The will then takes effect and has all the power.
Okay, so wills, the wills that we ask our volunteers to help our clients with are really designed for dealing with simple estates. Our clients' assets generally are a home that they are living in. And they may have some other personal effects they wanna dispose of, potentially bank accounts. We'll talk about other options for disposing of bank accounts. But generally it's about, you know, we really focus our wills work for clients who own homes and wanna leave those homes to folks. So we're not dealing with trusts. I'll talk about that a little bit later, but we're not dealing with complicated situations for the most part. The only wrinkle to that is sometimes if we've got a beneficiary who is living with a disability and might need a special needs trust, that we have some folks who are really experienced with those issues that we consult and bring in on those. But otherwise, these are fairly straightforward wills that we are talking about. One of the first important points with a will is figuring out who the executor is going to be. So executor is another term, sometimes they're called the administrator. It's technically an executor if you are named as the executor in the will. You're the administrator if you're not named in the will, but you're going to be stepping into that role. You'll sometimes hear the word personal representative, which is the kind of umbrella term for executor or administrator. They all really mean the same thing. The name doesn't matter too much, but when you're drafting a will, it's called the executor. Sometimes you still see mention of executrix, which is supposed to be a female executor. It's not needed to get that specific. Don't worry about deducing gender in what you're laying out in the will. But the executor is in charge of the decedent, the person's estate. It's really the client. And who is going to be in charge of dealing with what is in the will, of dealing with the client's debts, dealing with the assets, dealing with all the beneficiaries. So just like Vijaya talked about with powers of attorney, it should be someone who the client trusts. who's someone who's going to accept the responsibility and actually step up to do this. And probably someone who's not gonna be antagonistic with the rest of any other beneficiaries, right? Sometimes the executor ends up being the sole beneficiary, that's okay, but if there's gonna be other family members who are beneficiaries, if the client's describing their family situation to you and they say, oh, yes, I think I want my son to be my executor, and the way she's described her son is not someone who brings about family harmony, then that's a good time for you to just prompt like, hey, like, I know you also said you want your daughter to also get half of your property when you pass away. If you think there's gonna be any issue if your son's in charge of your estate, but he's supposed to make sure your daughter also gets half of it. It's a good time for you to ask that prompting question. Just like we talked about with powers of attorney, having co-executors is again not ideal. They generally have to act together, and it gets really tricky when they can't act together. We actually just had a case recently with a will that I believe that it's already been probated, and there are 4 co-executors named. It's a lot. Not all of them are alive anymore. And now, instead of having what could have been a great simple will that we're able to now help that family with, we now have quite a situation where we've got a lot of people who we need to figure out how we're gonna handle, how we're gonna get in touch with the ones who are alive and how we're gonna deal with the fact of some of the executors who have passed away. So having one executor is ideal and something that, again, just like you're gonna do with the power of attorney conversation, really kind of push the client to think through, like, what is the need? Why do you wanna have multiple executors? And is there another way around it? Is it that they're worried someone's gonna be offended? Or is it that they really think these 2 people need to act together for a particular reason? So beneficiaries is obviously one of the next important things you're gonna be thinking about and helping your client draft their will. Who is going to get the property that the client is going to leave to folks? So we've got a great questionnaire that we'll make sure that you all have access to, and that's in our resource library, that walks you through a lot of questions that you wanna ask the client when you're gathering information to put together their will. And it includes information like name, ages, addresses of the folks they think they want to leave property to. But some really specific questions that I just want to point out that are in that questionnaire are finding out if any of the beneficiaries are minors. Granted, they may not be minors when the will is ultimately probated one day, but if there's always a chance they could be, right? If they're minors right now, none of us knows what's going to happen to us, tomorrow or in a month or a year. So if they're minors, then we need to make sure that there is some provision in the will about who would act as guardian of that minor's estate or guardian of that minor's person, if they were still a minor when the client passes away. As I mentioned earlier, if any of the beneficiaries are living with a disability, then they may be getting a public benefit that could be in jeopardy if they were to get, for instance, a lump sum of cash that we may need to put in place a special needs trust that we build into the will itself. We usually have flagged those. Before we've asked you to step in on the case, we've usually already spoken with the client and gotten a list of who possible beneficiaries are and know if that's going to be an issue. But if there's someone that we didn't discover and that comes up and a beneficiary is living with a disability, that's something that we can pull in one of our mentors to help us figure out, does there need to be a special needs trust in this situation and what might it look like to make sure that that beneficiary doesn't lose any of those benefits in the future if they were to again get $50,000 from your client's bank account one day. Does the client want to make any charitable bequests to any organizations or churches? Those certainly come up in wills, and so we want to know if the client wants to include that in their will. Talking through contingent beneficiaries so that if a beneficiary that they've named has passed away, they can build into that will who they want to take that property in their place. If they don't do that, then it will fall in the will to the residuary clause, or it depends on the relationship of the beneficiary who's passed away to the client. There is some Pennsylvania law that will kind of kick into effect to talk about what's going to happen with that beneficiary's property that they were given if they are no longer alive when the will is being probated, but it's nice if it's already built in and the client has already made the decision ahead of time rather than kind of falling back on Pennsylvania law. You want to talk to the client about spouses. If they are currently married, making sure they understand that, you know, if they want to leave their spouse something in their will, that's fine. If they don't, that is okay. They should understand that if they are legally married when they pass away and they have attempted to disinherit their spouse in a will, Pennsylvania law doesn't fully allow them to do so. So there is something called the elective share, where the spouse who has been disinherited can try to elect against the will and claim a 1/3 interest in the estate. They can do that. They have, I can't remember if it's 9 months, a year from when the estate is probated to make to assert your elective share. Don't quote me on the time frame. I don't remember the time frame off the top of my head, but there is a way for a spouse to do that. So if they are still married and do not want to leave something to their spouse, they just need to understand they can try to. It's up to the spouse of whether they're actually going to contest it or not. But if the spouse does choose to contest it and try to take that 1/3 interest, they can. And then is there anyone that the client wants to disinherit? Any children they don't want to leave property to? You can list out in a will if they want to, like, I understand these are my children, right? This is who I'm choosing to leave my property to, this one child or these 2 children. To make sure that it's very clear in the document that that is your intent. You're not accidentally leaving anyone out. Yes, question.
So the $1 to the disinherited child, that's, I mean, I remember that from way back, that's not the way to disinherit a child.
Yeah,
It's just the children and the disinherited child is not named as a beneficiary.
Right, you do not need to leave a disinherited child a nominal $1 devised so that they, you know, technically get something. You can instead just list out and acknowledge who the children are of the client and then go on to just list as the beneficiary, the one particular child you want to get the property.
We also have some sample language that kind of specifies, you know, I have willfully chosen not to include this child because we've got some nice flowery language to make it sound nice, you know, like I think they're already cared for and I just don't want them to receive anything at this point. You know, so that way it kind of confirms that the client intentionally did not leave something for this child. That way, when the will is probated, they can't come back and say, oh no, mom forgot me or dad forgot me in this will, like I should be getting something, right? There's words there that says, nope, you're specifically not getting anything. So you can reach out to us for that language if you ever.
Okay, so next, beyond beneficiaries, talking about what is the client leaving to people in the will. So pretty much all of your clients who want wills own a home. That is a focus of ours, is trying to make sure we are getting homeowners in Philadelphia wills to try to prevent some of the tangled title situations that some of our other volunteers deal with. Trying to make sure we avoid that. So you want to talk to the client about and understand how does the client own the property? We will give you this information. We're not going to make you go hunting around and trying to find a deed. We will give you the deed. We will make sure that you are clear on how the client owns the property, but it's part of your conversation with the client. If they own the property outright, then they obviously want to devise the entire property. But it's also important for them to understand if they own the property as a joint tenant with right of survivorship with someone else who is still alive, or as a tenant by the entirety with a spouse, then they are only able to devise the property to someone if they are the last person to die in that situation. We've already told them that and advised them of that, but you can again reinforce that. We still want our clients in those situations to make wills because we never know. We don't know the order of who's going to pass away among multiple people listed on a deed. But we want to make sure that the client understands that if she owns the property with her husband, her will only really matters for this property if she dies after her husband, right? And making sure that she's clear on that. Talking through any personal property that the client wants to leave to folks. They can be specific if they want about particular pieces of jewelry. There is a way to have a separate memorandum that can be attached to the will that kind of specifies really specific pieces. If there's really specific items of personal property that they want to leave to particular people and that might change over time, they can do that. But if there's larger things like, I want, what's in my bank account, for instance, to go to these grandchildren, obviously all of that can be built into the will. And then another important piece in the will is the residuary clause or the residue. And that kind of says anything that I own when I pass away that hasn't otherwise been specifically devised or bequeathed to someone goes to this person or to these people. And that's a really important clause to have because there's always a reasonable chance that one of us is going to pass away owning something that we didn't own at the time that we made our will. So you want to make sure that that's in there. And that there is at least one beneficiary listed in that residuary clause. It's also important because the person named in the residuary clause actually is a person who will step in to serve as executor if the named executor or an alternate executor, if they're not alive or able to serve, it's actually the residuary beneficiary who then steps in to serve. So that's another important point to keep in mind, that person will have a little bit of power in that way. But again, the person that they want to get and kind of everything else. I know there's a question in the chat. I will turn to that at the end, but I know we're up against time. So I just want to make sure I get through a few more things for the folks who need to leave right at noon. Just talking briefly about will substitutes, there are some ways that folks can leave property to or leave assets to loved ones without going through the probate process and without having to have those things listed in their will. Life insurance, as a lot of us know, right, you can have that payable directly to a beneficiary. It is generally best to have that payable to a person or persons rather than to your estate. If you have your life insurance paid to your estate, it is now a probate asset that has to go through the probate process and you're going to be paying, inheritance tax on it when you otherwise wouldn't. Your heirs are going to now pay potentially income tax. So that life insurance, they really want to make sure is going directly to the folks they wanted to go through. The same idea with a pension. They can probably, if they have a pension, they should be able to have a named beneficiary that will go directly to those folks upon their death, usually just once a death certificate is provided. And then bank accounts also is something that may not have to go through the probate process. So if it's a joint account or payable on death, again, when their death certificate is provided, that may be all that is needed in order for the account to be paid out or for the other person to be able to access the account and not have to go through the probate process. And so just important tools for the client to keep in mind that can often be a complement to whatever you're helping the client leave to particular people in the will itself. Important notes on drafting. A big thing I would recommend is to, and this goes for really all of the documents, is to make sure that you review the documents with the client. I would try to do it before you actually sit down to have the client sign and notarize the will. And again, goes for the powers of attorney. A great way to do it is to send it to the client by email or mail ahead of time and then schedule a phone conversation to walk through each of the documents. Because very often when you do that, the client will either catch something like, oh, someone's name is misspelled. We had that recently. Or you know what, actually, I want to do a little change here. I'm going to change who's getting that in the will. And sometimes seeing it actually on paper is what makes that helps the client make that absolute final decision. A little easier to do that before you're actually sitting down with the client or the client's come into VIP and we think we've got the documents ready to go and it turns out we need to make some changes. It's fine. We will make the changes. We want the documents to be right, but it's a little bit smoother for all of us. I would recommend like kind of sending those hard copies to the client ahead of time and reviewing them before you actually sit down. Usually it also makes the notarization appointment pretty quick when we do that because you've already gone through the documents together and the client's very comfortable with what's in there. Execution, it will has to be signed and dated in front of 2 witnesses to be valid. It technically does not have to be notarized. However, it is significantly easier to probate a will in Pennsylvania if you have a self-proving affidavit attached to the will. The self-proving affidavit, I think, is one of the silliest things that us lawyers invented and threw into law, but it's there. And it says that if there are these separate statements where the testator, the client, And the witnesses attest that the testator was of sound mind and capacity, and the witnesses witnessed them signing the document, and that affidavit is notarized, then the will is considered self-proving, and witnesses do not need to appear for the probate of the will when the testator one day passes away. They don't need to appear and say, yes, we actually saw them sign this will, that really is their signature. It is much easier to admit that will for probate. So it's really important, it just makes things so much smoother, to have that self-proving affidavit done. And that is the document that needs to be notarized in order to be valid. Again, just makes everything a lot smoother. Okay, I'm gonna get to the questions in the chat. Legally separated spouse, if you've legally separated, I believe that you can no longer inherit. I would have to double check that, but I believe that if it's a legal separation, you can no longer inherit. If it's an informal separation, they can still inherit. Trust. Thank you for raising that trust issue. So we have a lot of clients who are talking to us about trust. Our goal is that by the time they get to you, we have disavowed them of the notion that a trust is a good idea. Trusts for most of us, including most of us in this room, are more complicated than they are worth creating and administering. There has to be a trustee who is going to properly manage all of the assets in the trust, who is going to actually be responsible, who's going to actively be a trustee. And otherwise, then you just end up with a trust where nothing is really happening and you have to go to orphans court to dissolve it one day. It's a pain. It doesn't solve a tremendous number of problems. There are obviously complicated estates out there in the world where you can, be very crafty with all the tax laws by putting things into trusts. That is not something that most of us are going to encounter, myself included. I always tell my clients, I don't have a trust. My family members don't have trusts. I'm sure some of us do have family members who have trusts, but it's not a great idea. It makes things more complicated than they're worth. It doesn't necessarily avoid taxes the way that folks think it's going to. And it can cause a lot of other issues. So I really encourage you, you can reiterate that to your client. If they're still continuing to talk about trusts once they're speaking with you, please feel free to let us know and we can re-engage them in that conversation to explain why we probably don't think it's a great idea for them. But yes, it is considered, a trust would be a will substitute. Trust can be built into the will itself. It can also be a separate document, right? An inter vivos trust. But again, just not something we recommend. Can beneficiaries be witnesses for the will? They can be, it's not ideal. It's better to have disinterested witnesses for the will. So we do aim to have, those of us who work here at VIP, we witnessed a lot of our clients' wills. That is generally a better practice than having the daughter who was left the property in the will as the witness. It doesn't mean that it's invalid, but it's generally better.
It just makes it easier to be contested if there are any issues between the children or anything like that, if the beneficiaries or the executors are not witnesses.
Okay. All right, we're almost, we're a couple minutes over time. If you have to skip out, we understand, but we're gonna cover just a couple last points for anyone who wants to hang on. Yeah, I can go ahead. So I talked a little bit already about our training materials. We have a training manual that kind of reinforces what we talked about today, and we will send this PowerPoint out to everyone as well so that you have that. We also have a estate planning questionnaire, which I really encourage you to use, that we have. Thank you, Linda, for shutting the door. And again, our template materials. So our template powers of attorney, living will, and wills. That again, we encourage you to use. You don't have to. If you work, at a firm that already has a template they want you to use, we are fine with that. But we have crafted these to try to be very targeted to our client situations, and Vijaya is really great about making updates as we become aware of things that we can update or language that we can improve. So we try to keep them in really good shape, so to speak, so that they are the most useful to you and your client. Other thing I just want to point out is that I mentioned this a couple of times and I'm going to say it again, the importance of you being a counselor and really listening to what your client is telling you. And I mean that, not that you wouldn't listen to your client telling you something, but listening to what they're not explicitly saying, but as they're describing their family or whoever, with their loved ones. and they're talking through different personalities. And then when they start to say, well, this is who I think I want to be my agent, this is who I think I want to get my property. Think back to what you heard earlier, and does that match up with the facts that they just told you about their situation and their family? And making sure that it does, and being that person who kind of throws out that prompting question, well, have you thought about this? Or you've talked a lot about this granddaughter who you're so close with, but she's not really mentioned any of these documents. Is that what you want? And maybe the answer is yes, but maybe it's something that they needed someone to throw out that prompting question to.
Okay, so here's that chart that I promised you. And it just goes through the actual requirements for execution of each document. So the will, again, required are the two witnesses, preferably disinterested. The notarization is not required for the will itself, but it is required for that self-proving affidavit. Without that self-proving affidavit, as Kelly mentioned, when the will is probated, the two witnesses actually have to appear in person at the Register of Wills to basically take an oath that says, yes, I witnessed this will, I saw the testator sign it, that is their signature, right? If they sign this self-proving affidavit, that stands as their word, essentially, so they don't have to actually appear. And that can be really good, especially when you have witnesses, you know, depending on how old the client is, the witnesses may pass away first, you know, and it makes things very difficult. For the financial power of attorney, the notarization is required. And so are the two disinterested witnesses. The advanced healthcare directive, which are the healthcare power of attorney and living will, do not require notarization at all, but we definitely suggest getting them. They do require the two disinterested witnesses though. And with all of these, we recommend sending the final draft to the client to review and then having a follow-up call with them to go over anything that they read, make sure the client understands what they've read and that they don't have any changes to make. We have a lot of misspellings, property numbers that can be typo issues. And we also, notary appointments in our office are free. We have a couple other resources. Some banks will do free notarizations for their customers. I know the TD Bank downstairs will only do it for their customers, but I think there are other ones who will do it for anyone. And if your client has some sort of mobility disability, we do have volunteer travel notaries that can go out to them. It's a very limited resource. We have like a handful of people who are willing to do that, to volunteer with us. So that's why we limit it to those who really can't make it into our office. But if that comes up, just reach out to us. We'll reach out to our volunteers and get one of them to help you out. The client should hold on to the original documents. They can have copies that they can share around with whoever they want. Their executor and agents should definitely have copies of these documents, or at least know where to find the originals or copies when the time comes. And for the healthcare power of attorney living will, they should have provide copies to their medical professionals. The medical professionals may want to see the original, but they should never be keeping it. They should always just take a copy. And then client holds on to the original. The agent will eventually need that original in hand to actually do anything.
And another great reason why it's great if the client is able to come in here to notarize, because we will make as many copies of those documents as the client needs. We will say, you know, okay, how many healthcare professionals, you know, doctors do you see? So that we can make sure that you have a copy of your healthcare power of attorney for each of them. And so we can help. It's a little easier if the client's actually in here for us to make sure they walk out with as many copies as are needed.
Right. And we will take a digital copy. We don't need a hard copy. But we do keep a digital copy on file, so if that client does come back to say, I need a change, we have that draft in there. It's pretty simple to make a change. We're more than happy to, if you're the volunteer, put you back with that client, or at least give you right of first refusal if you're available. And we'll also send you a copy if it's done in the office. In this office, we'll scan it in, we'll email you a copy afterwards anyway. And we have a template closing letter that you can provide to the client specifically for estate planning documents, which does a brief overview of each document that you've provided them, the will, the powers of attorney documents, and how to keep them safe. So like the will, we tell them all the time, don't keep it in a safe deposit box, because the safe deposit box, remember, all the powers of attorney documents, they die with you, right? So now no one has authority to get into that box. Your executor would have to have the will in hand to take to the bank to get into that box. And if they don't have the will is in the box, they can't get to it. So it's essentially like the will doesn't exist, right? So we talk them through all of that is in the letter. And it's already drafted. You really just have to fill in the client's information at the top, sign the bottom. If they didn't get all of the documents, you could just take out the paragraph pertaining to the document they didn't receive. You send it, make a copy, forward us a copy, so we know the case is closed and you're good to go.
Yeah, and again, any wrinkles that we didn't cover today that come up in a case that you're handling, just reach out to us. There's no wrong person to reach out to a VIP. Sometimes people reach out and say, I don't know who the right person was. There's no right person.
Correct.
Reach out to us. We are a small staff. We talk to each other all the time, and it can be the person who referred the case to you, or it can be Vijaya or me, or just pick a random person at VIP and we'll make sure that you get the answer you need, and that, you know, if we need to step in and help resolve an issue, we will do that. We want this to be a smooth process for you. We don't want you spinning the wheels.
Just quickly on the part where you said about avoiding a will with life insurance and just beneficiaries and stuff, what about the house?
So the question is about avoiding going through probate, if you're trying to, if you have a house that you wanna leave. Most of the time, the best option is to just make a will. We talk with clients a lot who are trying to, you know, just change the deed to add their daughter onto title, or just give her the property now. We have those conversations a lot with our clients. In fact, some of the clients you will be working with on estate planning documents initially came into us saying, I think I want to add my daughter to the deed. And we eventually got them around to a place to understand that's probably not the best idea, but making a will would be a really great idea to make sure your daughter gets the will or gets the house. The reason is that we always tell our clients is that once you've added someone onto the deed or completely taking yourself off and just given the property to someone else, you can't change that without that person's consent. It doesn't matter if you bought the house, you've made all the improvements for the house, you've done every single thing for that home. Once you add someone's name onto the deed or give them title to the property, now that person has either complete or partial control, depending on how much of an interest you gave them, and they have to agree to whatever is going to happen with that property. And for our clients, we worry about that, right? We want our client, if they are staying in the property and that is their home, to have control over it. And if, you know, if something were to happen and they were to have a falling out with that person, or that person just simply moves away and now they want another person in the family to get the property, it's a lot more complicated now if you've added someone to the deed rather than just calling VIP and saying, hey, I need to update my will, you know, I need to change it for my daughter and my son. That is so much easier for us to help take care of. So that's usually what my response is.
And especially for our low-income clients, a lot of them are receiving public benefits. And when you transfer partial or even all of title to someone else without, you know, actually selling it, it can make you ineligible for those benefits. So that's also part of the conversation we have with those clients. And usually they're like, oh, wait, I'm gonna lose my SSI, or, you know, I'm 75, I don't need medical assistance now, but I might need it a few years from now, you know, and then, you know, they don't wanna risk their eligibility for those things, including just your normal city home repair programs. You know, cause it's income eligibility and, who lives in the home. If daughter's on title, she doesn't live in the home, she lives elsewhere. You know, it could potentially disqualify that home for the city repair programs.
So if there's only one beneficiary, there's no other possible beneficiaries, but you make a simple will, does the beneficiary really have to take it, if the accounts are coming in and the house that stays go? They don't really have to take it to probate if there's no other siblings, anybody, nobody's gonna contest it, they're not required to take it.
So the question is that if there's just one heir, one beneficiary, and, you know, there are already names on it, account with co-owners of bank accounts, they're already, are you, in your scenario, are you saying they're already listed as like a joint tenant with right of survivorship on the deed? Sure, if that was the case, then no, there may not be anything that they actually need to go through probate for. They may be able to just do a deed of confirmation. So that is possible, and that frankly, that is, yes, easier for that surviving beneficiary to do that. Who it jeopardizes is it jeopardizes the client who's currently the homeowner, because now they are putting a lot of faith and trust in that person who they've added the title, and as Vijaya pointed out, they are also risking eligibility for a number of benefits once they do that. So there's a lot of risk to the client during their lifetime. Yes, it is definitely easier for the joint tenant with right of survivorship who's the survivor once the first person has passed away. So it's a balancing act.
Mhm.
Okay, all right, well, thank you. Thanks to those of you online who hung on to the bitter end. But we will, we do have a lot of clients, who come into us for help with estate planning. We always have more coming in. So we will circulate after this a list of some available cases for clients who currently are looking for volunteer attorneys, and we're gonna have more in the coming weeks. We have a lot in the office right now that we're working with. So we know we're gonna have more clients in the coming weeks who could use help with estate planning. So we will reach out to you, and you can let us know if you're interested and ready to work with a client now. If you say, you know what, I'm really busy the next few weeks, can you reach out to me in mid-November? We'll do it any, you know, whatever way works for you, but hopefully this makes you feel prepared and confident that this is something that you can definitely do, and it's such a huge benefit to our clients to have this peace of mind and to know that things will be taken care of if they no longer have capacity or when they pass away, and that the right people will be ready to serve and things will happen according to their wishes.